Members of the Historical Society of the Courts of New York, Chief Judge Fiore, Judge Rosenbat, Marilyn Marcus, I hope I have that correct, officials of this organization, members of the bar, and guests. The Historical Society of New York, the sponsor of this event, has provided a fitting program for an organization whose mission is to preserve, protect, and promote the legal history of New York, including the proud heritage of its courts and the development of the rule of law. Our constitutional tradition has suffered neglect for too long, buried as it is under the massive attention given to our national document. The vote this November asks citizens to engage in civic action of the highest order by the exercise of one of the few remaining forms of popular sovereignty in this nation. Informing citizens of this vote and its significance is quintessentially the task for the Historical Society of the Courts and the Bar Associations of New York. For that, those of us who have labored in this vineyard for some years are deeply appreciative. It was 20 years ago today, well, maybe not today, when I stood here along with Hank DeLay, who's here tonight, Michael Cardoza, Shirley Eberly, the president of the Rochester League of Women Voters, and Professor Herskovits to debate the question of whether we should hold a constitutional convention or not. I was in favor. I hope I'm more successful tonight. The subtitle of my talk, Back to the Future, aside from the clever paradox posed by the phrase, is there any other justification for this plagiarism? There is. It came to me after reading two letters that John Jay wrote to Gouverneur Morris and Robert Livingston just before and after the 1777 Constitution was adopted. On April 17, 1777, Jay was called away to care for his dying mother. In his absence, some changes were made that aroused his ire. The first conferred on judges the power to appoint clerks of their respective courts. He described that measure as patronage and nepotism. The second required attorneys to be separately licensed in each court in which they would practice. He described the provision as, and I quote, the most whimsical, crude, and undigested thing I've met with. Did it make any sense, he continued, to require attorneys seeking general license to obtain admission in the Supreme Court, 3 mayor's courts, 13 inferior courts, courts of common pleas, 14 sessions courts, and Lord knows how often or in how many courts of oyer and terminer and jail delivery? Does that sound familiar? Can we see in Jay's critique the shape of things to come as we struggle to bring order to the courts and to make them more user-friendly? If I have time, and I probably won't, I shall return to this topic. Let me now turn to this PowerPoint presentation, which gives you a kind of very fast view of what I consider the highlights and the significant parts of the constitutional tradition of New York. I hope I've emphasized the kind of things that will illuminate our current position, as well as the important and interesting historical data. And maybe someone will even ask me, what the hell is that picture doing as a start? The Constitution, I hope, is not, it is implied, in ruins. Conventions by the numbers. New York has had 9 constitutional conventions, 1777, 1801, 1821, 1846. Well, you can read them there, right up through 1967. The current gap between conventions, if you look at the numbers, is the longest in New York's history. New York has adopted 4 constitutions, 1777, 1821, 1846, and 1894. The current Constitution adopted in 1894, was substantially revised in 38, but is not considered a new constitution since it was not submitted as a document in toto to be approved or disapproved. All but one of the conventions have been unlimited, meaning that once they're called, all's fair. Nothing is off limits except those provisions of the federal Constitution which would limit what the delegates could do. We only had one limited convention in New York. It was called in 1801 to consider the reapportionment and the council of appointment. The current language, placed in there in 1846, seems to preclude a limited convention. This causes a sadness in my heart, because I'd like to see something like that available to New Yorkers. In any case, the provision says, shall there be a convention to revise the Constitution and amend the same, and under that old principle that the inclusion of one is the exclusion of another, apparently most have concluded that a limited convention is not within the purview of constitutional conventions being called in New York. Historic role of conventions. Conventions have played a central role in the constitutional history of New York. Most of the provisions, I'll emphasize this, most of the provisions in the Constitution that we point to with pride have been inserted by constitutional conventions. Nearly all the rights provision, I could say this twice and not be redundant, nearly all the rights provisions in the Constitution that we value, that are important to us, were the results of constitutional conventions, not legislative action. Conventions have also given us a Constitution that reflects and sustains our ideals. What have conventions done? Well, obviously, this starts with very elementary things. They've adopted basic structures of government. In 1777, we had this tripartite structure that we're all familiar with a bicameral legislature. But it's also important to notice that there was no hard and fast rule about what was separation of powers or not. The Council of Revision, which was a kind of a review body of what the legislature could do, was made up of the governor and members of the court. That clearly transcended traditional separation of powers lines. And we've always done that in New York. Nonetheless, there is this basic tripartite structure. In 1821, the convention lodged the veto and appointment power in the governor. In 1846, the convention established the Court of Appeals as the state's highest court. And, I might add, made all the courts of the state elective, an issue which we are still grappling with today. In 1894, the convention established the current department structure of the judiciary. This is a little sidebar here, but in the 1894 convention and the 1915 convention, we witnessed in New York the last hurrah of Protestant Republican New York. And there were attempts at that convention to preserve that New York. And it occasioned a great debate between Lewis Marshall, who was a delegate to the 1915 convention, and a very prominent German Jewish civil libertarian lawyer, and another famous New Yorker, Elihu Root, who exuded the Protestant ethic and the tradition of noblesse oblige, but who also felt that the increasing numbers of immigrants from Southern and Eastern Europe were not compatible with the rule of law tradition of the Anglo-Saxon mind. And that debate arose heatedly between Marshall and Elihu Root both outside the convention and inside the convention. And in a move to attempt to solidify or keep out these immigrants, a proposal was made that you couldn't vote unless you could read in English. And Marshall got up and thundered about that. If you want something like that, say, read in any language. And he then started to talk about the number of Yiddish publications read by tens and hundreds of thousands of Jews in New York, and the literacy rate that they had, independent of the English. So that convention for me was a kind of last hurrah for the attempt to hold back the borders or the walls that were crumbling in the face of a new New York. So Lewis Marshall is, and here's the picture of Elihu Root, whose picture also is in, I think, one of the rooms here at the New York Association, which Hank was kind enough to point out. What have conventions done? Well, they've added rights for defendants, for example, in the 1777 Constitution had no formal Bill of Rights, but contained a number of rights provisions: jury trial, right to counsel, due process, the vote, religious liberty. The 1821 Convention created, for the first time in New York, a separate Bill of Rights, made it in Article 7. It added a right to grand jury, freedom from self-incrimination, habeas corpus, and a free speech clause. 1846, the Convention prohibited excessive bails and fines. 1938 Convention added a prohibition against unreasonable search and seizures. By the way, the great debate that took place, it's just a wonderful read to see the forces who were not so much opposed to adding a separate search and seizure clause. The great debate took place over whether an exclusionary rule should be added to the Constitution. And Senator Dunnigan and Dewey, outside the convention, they introduced his speeches. There was a tremendous and lengthy debate, I think one of the great debates in the annals of New York constitutional history, over this fundamental civil liberties question, before it became an issue of some significant importance for the Warren Court, although it had been raised at the federal level. Here, just as kind of a sidebar, these are cartoons that are in the archives, and they are by Jerry Costello, who did a lot of these cartoons for the New York Knickerbocker. Long gone, right? I don't know when it disappeared. I don't think it's any longer in extant. But here's one giving some idea of what the one cartoonist thought about this Constitutional Convention in 38, what it ought to do. What the people expect: a lot of this, the job of revising our state constitution, and little of this. This is an old canard in the newspapers, politics. And the second one here, he wants it short and plain. State Constitutional Convention cookery. Just give me something I can digest. And this kind of anticipates a famous remark that Al Smith made at the 38 Convention, when he said, we ought to have a constitution, this is typical Al Smith, we ought to have a constitution you can fit in the back pocket. You know, that was it, simplified. And this is, of course, in anticipation of that view. And there he is. His last hurrah, speaking of last hurrahs, Al Smith favors whittling Constitution to the pocket side of the areas with a cigar. It looks like it's about 6 or 7 inches long. He's got his vest, his brown derby, and his forward-looking face, and he's talking there in this article about the importance of getting rid of all the stuff in the Constitution that simply doesn't belong there. What have conventions done? Well, they provided the ground rules for state and local fiscal policies. There was a referendum requirement for state debt added by the 1846 Constitution. This is a very important bone of contention that any convention that does meet in the future has to address this question: does this debt limitation make sense, this referendum? Because about 94% of the state's debt is not referendum-based debt. I mean, we've found effective ways to get around it. Maybe it doesn't belong there, but the 1846 Constitution put it in. There's a ban on gifts of state credit, added again by the 1846 Constitutional Convention. There's a provision that prohibits state and local guarantees of public authority indebtedness, added by the 1938 Convention. That's still an issue of some difficulty. What have conventions done? They've been socially progressive. Environmental protection, such as the Forever Wild, the Conservation Bill of Rights, that's largely aspirational, but nonetheless without some significance. Some people suggest that if we did have a constitutional convention, that Conservation Bill of Rights, the right to clean air and water, not be aspirational, because it's discretionary at the legislature's will what it will do about that, that we could tighten that up and say, look, we want to mandate it the way we mandate something like education or the Forever Wild provision. There's a right, of course, to aid and care of needy, to put in by the 1938 Convention, and also the authorization of low-income housing. Third, what have conventions done? We've given the citizens the opportunity to revise state constitutions without government approval. Every 20 years, the people get to decide whether to hold a constitutional convention. Can you imagine the legislature giving this power to the citizens? I can't. It's a remarkable example of prescience, I think, because there are times when, for various reasons, the governmental apparatus stops functioning, loses the trust of the public, becomes constipated and difficult, and things need to be done. And I think the people who put this in 1846 realized that, and it was precisely the basis for this every 20 years provision. It has its problems because there's a rhythm to every 20 years that may not coincide with the rhythms of problems and reform movements. Nonetheless, it was one of the most valuable things, I think, that the 1846 Constitutional Convention did. Unsuccessful constitutional conventions. The work of 6 of the 9 conventions was largely approved by the voters. 3 conventions, 1867, 1915, and 1967, did not have their work approved by the voters. However, the 1867 convention submitted a separate judiciary article approved in 1869, and much of the 1867-68 convention's work was included in the recommendations of one of the, I don't know whether it's the first New Jersey, New York vie for this, one of the early uses of a constitutional commission to provide recommendations to change things, those recommendations were made to the legislature, and they were based on much of the work of this convention. 1915 convention's work was adopted by later amendments in the 20s. The short ballot, the executive budget, the executive reorganization, all of these were the work of the 15 convention, later adopted by amendments in the 20s. The 1967 convention, of which we will have a panel here, so I won't say much about it, the Conservation Bill of Rights, state financing of the court system, redistricting commission, found their way into the state commission, the Constitution in one form or another over the next 25 years or so. The future of constitutional reform, decline or dormancy. The last state constitutional convention was held in 1967, a half century ago. In the last 30 years, the state has adopted 26 amendments, the lowest number for any 30-year period in the last century. From 1946 to 1955, there were 36 amendments adopted. From 1956 to 1965, 36 amendments were adopted. And more importantly, the amendments adopted between 87 and 2017 did not address any of the fundamental problems facing the state. They dealt with non-structural issues such as civil service additions, adjustments in the Adirondacks, exchanges of lands, those kinds of things. Important, of course, but not in any way involving the structural issues such as that we need to deal with. They had gambling provisions, exceptions to that, exclusion for debt limits of sewage facilities. Every time I think of that, I think that stinks. Finally, that's my quick review of the constitutional conventions. I want to just conclude with a note towards the judiciary article. If you take the judiciary article and the 2 articles, state and local finance, together, they constitute 30,000 words of the 50,000 document, raising very important questions about, are we going at this problem of the judiciary article in the Constitution and finances in the wrong way? Do we need to do that? Why do we do it? So take a look at this quick review. I took the words, thank the Lord for computers. You can do this just by looking at the bottom of the page. In 1777, they barely talked about it. They didn't mention, only one court was even mentioned in 1777. There were 296 words. 1821, there were 913, not bad. 1846, that was the first constitutional convention to really give the judiciary some attention, 3,000. 1894, 4,000. But notice what happens. From 1894 to 1938, the size doubles. Then in 67, you have a retrenchment, if you will. It wasn't adopted. They really went after it. They tried to simplify and reduce. It got it down to 4,000 words, but that Constitution was rejected. Then if you add the work of the 61 Amendment, that was a wholly new amendment for the judiciary, and the 75 and 77 amendments, you have a Constitution of 16,000 words. It's doubled again. So the question I want to ask in conclusion is, why do we have such a large, complicated judiciary article and so much continued dissatisfaction? Is it just that the justice is so important that we have to put all that detail in there? Is it that the supply simply has not kept up with the demand and we have to keep adding and changing? Is it that the details are meant to prevent a runaway legislature from, if it had the discretion, to politicize the courts? Or is it the framework and assumptions that we take into writing a judiciary article that need re-examining? I'm not sure which it is and whether we have to make those choices, but let me conclude by a remark by a famous, rather sour-minded writer, Samuel Beckett, wrote a novel in 1946 called Mercier and Camier, and he said this: "We must choose," said Mercier. "Between what?" said Camier. "Ruin and collapse," said Mercier. "Could we not somehow combine them?" said Mercier. So I leave it for the second panel to decide whether we're caught in a Beckett dilemma or whether there is a way out. Thank you.